Good morning, everyone. I want to welcome everybody here today on this lovely morning. I'm going to turn it over to Mr. Butler for a few words of wisdom before we begin.
Thank you, Mr. Chairman. I just wanted to talk about an administrative matter briefly. We're moving on pretty well with this case. You may recall earlier this week I'd asked the parties to discuss the non-pre-file witness aspects of this case, which presumably would take place on the week after Thanksgiving. I will say the Commission's goal is to finish the entire case by the end of Wednesday of the week after Thanksgiving. That's our goal. So with that in mind, I had asked the parties to get together and discuss various aspects of the non-pre-file witnesses. In other words, what witnesses you might offer. I know there were a number of witnesses in common on the various lists we've got. And although we've gotten several lists on proposed such witnesses, we were interested in the parties' viewpoint at this point. So we were hoping that the number of witnesses as listed would be pared down to some degree. Of course, some of them have been presented or will be presented before the end of the pre-file time. So what we're basically asking is, by the close of business on Monday, we would ask the parties to please get together and, if possible, agree on a list of non-pre-file witnesses and or depositions that you wish to present in that portion of the case. Keeping in mind, if possible, the goal of the Commission to finish the entire case by the end of Wednesday of the week after Thanksgiving. Also keep in mind that we have requested proposed orders by December 7th, which should enter into the equation as well. So that is my request of you this morning, that you submit by the end of business on Monday of next week a joint list, if possible, of proposed non-pre-file and or witness or deposition witness testimony. And if you cannot agree, certainly you can submit separate documents, and then we'll take a look at them. But in any event, of course, the Commission has a final word on any list that you may submit, which, of course, we will let you know as soon as possible. So, Mr. Chairman, that's my administrative word this morning, and I thank you very much and turn it back over to you.
Thank you, Mr. Butler. He's so much nicer than me with asking you. I think he was telling you. Mr. Challey, you're standing before we...
Yeah. Yes, Mr. Chairman, thank you. Just one housekeeping matter. During Mr. Winnick's deposition yesterday, there was talk of an exhibit to an email that was not included in the exhibit that was actually provided to the Commission and to the parties at the time. We do have that attachment to the email, so we wanted to, as the parties had requested, provide a copy and enter it into the record as the next hearing exhibit.
Okay, we will enter this exhibit as exhibit number 124. Thank you. And as soon as we get that out, Mr. Reed, it's all yours.
Good morning, Mr. Chairman. I'm Joe Reed from McGuire Woods on behalf of Dominion Energy, and we are prepared to present our witnesses at this time. We're presenting them in two panels. The first panel consists of Mr. Jim Chapman, and Mr. Chairman, I'm going to allow you an opportunity to show off on your name pronunciation yet again, Mr. Prabir Pruitt and Mr. Jim Warren. If we can begin with Mr. Chapman, Dominion Energy calls James R. Chapman to the stand. Sir, if you would state your name after you're sworn in. Thank you, Madam Court Reporter. Beginning with Mr. Chapman, sir, could you state your name for the record?
Good morning. My name is James Chapman.
Let's get your microphone on. Punch that little button till that red light comes on and speak into it.
Good morning. My name is James Chapman.
Mr. Chapman, by whom are you employed and in what capacity?
I am Senior Vice President, Chief Financial Officer, and Treasurer of Dominion Energy, Inc.
Have you prepared or caused to be prepared under your supervision direct testimony of 23 pages that was filed with the Commission in this docket?
Yes, sir.
Do you have any changes or additions to your pre-filed testimony?
No.
If I were to ask you the same questions appearing in that testimony here today, would your answers be the same?
It would, yes.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of James R. Chapman be read into the record as if given orally from the stand.
Mr. Chapman's pre-filed direct testimony will be read into the record as if given orally from the stand.
Mr. Chapman, have you prepared or caused to be prepared under your supervision 2 exhibits labeled as JRC-1 and JRC-2 that were previously filed with the Commission as attachments to your pre-filed testimony in this docket?
Yes.
Do you have any changes or additions to these exhibits?
No, I do not.
Mr. Chairman, I would also move into the record as the next hearing exhibit the exhibits attached to Mr. Chapman's direct testimony and labeled as exhibits JRC-1 and JRC-2.
Mr. Chapman's exhibits JRC-1 and -2 will be entered as exhibit number 125.
Thank you, Mr. Chairman. Mr. Chapman, have you also prepared or caused to be prepared under your supervision rebuttal testimony of 9 pages that was previously filed with the Commission in this docket?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No.
If I were to ask you the questions appearing in that testimony here today, would your answers be the same?
They would.
Mr. Chairman, I would ask that at this time the pre-filed rebuttal testimony of James R. Chapman be read into the record as if given orally from the stand.
Mr. Chapman's pre-filed rebuttal testimony will be read into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Chapman, have you prepared a summary of your testimony?
I have.
We will pass that out, and as soon as it is passed out to the commissioners and the parties, I would ask that you deliver that summary. All right, sir, you may proceed.
Thank you.
Oh, apologize. Everybody got one?
Got a couple more parties of the parties back here, interveners.
All right, I think we're ready.
Thank you. Good morning, Mr. Chairman, members of the Commission. My name is Jim Chapman. I'm glad to be here before the Commission today and to be the first of 5 witnesses from Dominion Energy who will take the stand in these proceedings. I will focus my summary on a few key points, and witnesses Purohit and Warren, who join me today on this panel, will provide more granular detail on the specific mechanisms of our proposals. First, I want to share from a financial perspective what makes Dominion Energy such a stable player in the energy market. Next, I'll address the customer benefits plan on a high level and provide an overview of the alternative customer benefits plan we have set forth, comparing both to the plan put forward by ORS. Finally, I will say a word about some of the other financial issues that have been raised thus far in this proceeding, including the debt securitization suggestions which have been put forward. Much has been made over the last couple of weeks about SCE&G's financial condition, and I want to take some time here to tell you about Dominion Energy's. Dominion Energy is one of the largest public energy infrastructure companies in the country and globally in terms of equity market capitalization. It is publicly traded on the New York Stock Exchange and is a member of general and industry-specific equity market indices, including the S&P 500, the Dow Jones Composite Average, and the Philadelphia Stock Exchange Utility Index. Our operations are heavily weighted to state and federally regulated energy infrastructure, which is viewed favorably by investors. Our company has assets over $79 billion, and we maintain revolving credit capacity of $6 billion with liquid assets at any one time, typically well in excess of $2 billion. Dominion Energy has consistently maintained strong credit with current ratings at BBB+ from both S&P and Fitch and Baa2 from Moody's. Our abundant access to capital markets enables us to invest prudently and confidently in our operating companies, and that would certainly be the case with SCE&G following a merger closing. We plan to incorporate SCE&G into the Dominion Energy family in a way that is consistent with these time-tested financial characteristics and values. That means SCE&G will obtain access to Dominion Energy's credit facilities, replacing its current liquidity challenges. SCE&G will remain a standalone, publicly rated entity that issues debt and other securities to public markets in line with current practices, but with the added strength of Dominion Energy's backing and resources. I will now turn to the merger plans. At the beginning of this process, Dominion Energy put forth its customer benefits plan, an innovative approach that we continue to believe offers a very positive solution for ratepayers. The details of that plan have been discussed, but it is worth reiterating how this plan benefits SCE&G customers and the state of South Carolina while keeping this combination financially viable from Dominion Energy's perspective. The customer benefits plan, Plan A, is best known for its upfront one-time rate credit of $1.3 billion, a way to refund the majority of customers' historic contribution to NND costs. Plan A also dedicates $575 million in refunds, also funded by Dominion Energy, to support a 3.5% bill reduction, which, when combined with the savings from federal tax reform, represents an approximately 7% cut to the bill customers would otherwise be paying under the BLRA. The plan also includes write-offs of previously incurred costs and regulatory assets totaling $1.8 billion, more than a third of the total NND project costs. To facilitate more stability, we have also pledged to freeze base electric retail rates until at least January 1, 2021, and promise not to seek reimbursement of the $180 million acquisition of the Columbia Energy Center. These are significant multi-billion-dollar commitments that substantially reduce the NND abandonment burden for customers, providing relief that I believe SCE&G could not provide on its own. We've also listened to the perspective of various stakeholders and developed an alternative customer benefits plan, Plan B, to meet their concerns over the long-term rate relief. This plan maintains the economics needed to close the merger, but eliminates the upfront cash payment and reconfigures those funds to produce lower bills over a 20-year period and to recover costs at a lower return on equity. Plan B also limits the future rate base to investments made on or before March 12, 2015, as ORS recommends. The alternative customer benefits plan produces a typical customer bill of $126.96, only $1.62 above current experimental rates under Act 258. Either plan is acceptable, and I can confirm that Dominion Energy will close on the merger in either scenario, subject to all other closing conditions being satisfied. On the other hand, as Mr. Farrell notes in his testimony, Dominion Energy cannot accept the terms of the ORS optimal benefit plan and will not close the merger if it is implemented. Turning to the third topic, there's been quite a bit of discussion in this matter about the concept of securitizing some or all of the NND investment that is not being written off. And I address this issue in my rebuttal testimony. I do not believe that securitization is a magic bullet or panacea for the NND cost recovery issues for several reasons. First, as has been stated many times and is now certainly obvious, there's not enabling legislation in place here in South Carolina for securitization. I'm not a lawyer, but I understand that bodies like this one don't typically decide issues that are not actually before them. But even if this commission would consider exploring securitization in the hypothetical event that the General Assembly took steps that had not to date since the project's abandonment, there are several additional factors which counsel against this option, in my opinion. Investors in any securitized debt and the credit rating agencies which would be required to rate such debt will be focused on the security and certainty of repayment over a long period of time. Any suggestion of an uncertain political climate would call that into question and impact investor appetite for such securities and the required return on these securities. Needless to say, there is such an environment, I believe, here in South Carolina. There's also the issue of breakage fees. The debt instruments in place have prepayment penalties. These may total an amount approaching $1 billion, to my understanding. The size of SCE&G's NND obligation would render a total securitization by far the largest such transaction since before the 08-09 financial crisis, when such kinds of large securitization transactions were more common. That will certainly affect pricing, and more importantly, would bring into question the entire feasibility of transaction execution. The debt will continue to be consolidated by SCE&G in SEC financial statements, and the ability of SCE&G to treat this debt as an off-balance sheet obligation by rating agencies and fixed income analysts is in question. And finally, there is the punchline, so to speak, with respect to the Dominion Energy combination. Securitizing the N&D debt, as witnesses have testified, removes any equity return on that investment in the future. That would have a significant impact on SCE&G standing alone, and it would preclude Dominion Energy from closing the merger with SCANA, given the need for an appropriate return to our shareholders from this transaction in light of the material, customer, and other benefits being funded by Dominion. To be clear on this point, if the Commission were to require or direct securitization of the N&D investment as an outright or contingent condition of this merger, that would unfortunately defeat the merger. We need to be totally transparent with the Commission on this issue. Our plan offers billions of dollars in concessions to customers. Those benefits far exceed any reasonable estimate of securitization benefits, even assuming it could be feasibly and reasonably accomplished. Both of the company's benefits plans significantly limit the N&D rate-based recovery going forward compared to the total level of investment. But if that opportunity for a limited return is restricted further or eliminated, the merger just can't make sense for Dominion Energy. Dominion Energy wants to further serve the people of South Carolina, and we believe we have offered reasonable plans which enable us to do just that, while taking into account various stakeholder concerns, including those of our shareholders. Throughout this hearing, various stakeholders have raised potential alternative paths, including securitization, as I've discussed, as well as bankruptcy and other non-merger options. These speculative and tenuous choices may provide marginally lower rates in the short term. We believe that such options forego an opportunity for lasting stability and growth through SCANA's combination with Dominion Energy. We are hopeful that the Commission will decline these alternatives and adopt one of the merger plans on the promise of a more positive future for SCE&G. Thank you, and that concludes my summary.
Thank you, Mr. Chapman. And now, Mr. Chairman, if we could turn to the second witness, Mr. Pruitt. We would call Prabir Pruitt to the stand and ask that you state your name for the record.
Good morning. My name is Prabir.
Let's get that microphone, yeah, and get it close to you, too, because it's...
Thank you. Good morning. My name is Prabir Purohit.
By whom are you employed and in what capacity, Mr. Pruitt?
I'm the Director of Mergers and Acquisitions and Financial Analysis at Dominion Energy, Inc.
Mr. Pruitt, have you prepared or caused to be prepared under your supervision rebuttal testimony of 11 pages that was previously filed with the Commission in this docket?
Yes.
Do you have any changes or additions to your pre-filed testimony?
No.
If I were to ask you the questions appearing in that pre-filed testimony here today, would you provide the same answers?
Yes.
Mr. Chairman, at this time I move that the pre-filed rebuttal testimony of Prabir Pruitt be read into the record as if given orally from the stand.
Mr. Pure, I was going to get it just exactly like you said it.
Purohit.
Pure.
You got it.
Close. I think it's better than you, too. His rebuttal testimony will be read into the record as though given orally from the stand.
Thank you, Mr. Chairman. Have you also prepared or caused to be prepared under your supervision, sir, supplemental rebuttal testimony of 8 pages that was previously filed with the Commission in this docket?
Yes.
Do you have any changes or additions to your pre-filed supplemental rebuttal testimony?
Yes, I do. I have 2 changes. On page 2, line 3, the date, August 14, needs to be changed to September 24th. And on page 6, line 10 and 11, both plans need to be changed to the alternative customer benefits plan.
All right, sir, with those changes, if I ask you the questions appearing in that testimony here today, would your answers be the same?
Yes.
Mr. Chairman, at this time I move that the pre-filed supplemental rebuttal testimony of Prabir Pruitt be read into the record as if given orally from the stand.
Mr. Pure's supplemental pre-filed testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Pruitt, have you prepared a summary of your testimony?
I have.
And we'll ask Mr. Patterson to pass that out to the parties, and when he has done that, if you would deliver that summary. All right, sir, you may fire away.
Good morning, Mr. Chairman, members of the Commission. My name is Prabir Purohit. Thank you for the opportunity to appear before you today. My testimony focuses on two issues. First, I set forth the applicant's Alternative Customer Benefits Plan, Plan B, which was prepared in response to requests from interested stakeholders. And second, I address certain comments from ORS witness Colin regarding the ORS plan. Let me first discuss Dominion Energy's Alternative Customer Benefits Plan. We developed this plan in response to parties who expressed a preference to replace the upfront bill credit in exchange for the lowest possible electric bill over the N&D recovery period. The Alternative Customer Benefits Plan presents such a proposal while preserving the merger economics. To be clear, Dominion Energy still supports the Customer Benefits Plan, Plan A, as originally proposed, but will also close the merger under the terms of the Alternative Customer Benefits Plan if that is the preferred approach. The Alternative Customer Benefits Plan would reduce the typical residential electric customer's bill to approximately $126.96, which is significantly below the $147.53 May 2017 typical customer bill, and appreciably less than the approximately $137 bill under the originally proposed customer benefits plan. Importantly, as shown in Exhibit 52, the Plan B bill is only $1.62 above the current experimental rates. Overall, Dominion Energy's alternative plan provides an all-inclusive bill reduction of nearly 14% relative to May 2017 levels. The Alternative Customer Benefits Plan achieved this low rate by providing a total of $1.91 billion in refunds over a 20-year N&D recovery period, rather than through the upfront rate credit. The revised plan lowers the company's requested return on common equity to 9.9% from 10.25% in the original plan. It also reduces the cost of debt from the original 5.85% to 5.56%, consistent with the ORS proposal. Notably, this plan reduces the N&D investment to be recovered by approximately $550 million to $2.772 billion from $3.327 billion as requested under the Customer Benefits Plan. Dominion Energy is not conceding that any of SCE&G's investments in the N&D project were imprudent, but in the spirit of reaching a compromise and facilitating the merger closing, we developed this alternative plan, assuming allowable N&D investment spending ends on March 12, 2015, the date ORS contends the Commission should begin disallowing recovery. This assumption essentially eliminates the hotly debated prudence question from the discussion in a way that still permits the merger to close. If this Commission values setting lower bills in the long term over upfront recovery, Dominion Energy's Alternative Customer Benefits Plan provides an economically sound vehicle to close the merger with the terms that advance this objective. Let me now turn to the second issue in my testimony. As Dominion Energy has repeatedly made clear in its pre-filed testimony, it will not close the merger if ORS's plan is adopted by this Commission. In short, the ORS plan fails to strike a fair and appropriate balance between the need to provide significant rate relief for customers and the need to maintain the viability of the utility. I have read the testimony of ORS witness Lane Collin, and I would like to spend a few moments addressing some of his contentions about the proposed implementation of the ORS plan. Mr. Collin objected to Dominion Energy's allocations of deductions for the net operating loss carryforward, or NOLC, deferred tax asset. His concerns are misplaced, as the NOL is an integral component of a complete economic proposal that allows the merger to move forward. It should not be disaggregated from the overall customer benefits plan. Dominion Energy witness Jim Moran will discuss these matters further. Mr. Collin also proposes a merger savings rider with a rate reduction of $35 million in the first year and $70 million in the second year, continuing annually thereafter. Mr. Collin does not provide valid support for this suggestion and makes problematic assumptions. For example, he disregards various implementation costs and wrongly assumes that Dominion Energy will engage in extraordinarily high headcount reductions. Dominion Energy witness Bob Blue will address these issues in more detail. Mr. Collin recommends that the Commission terminate recovery of the BLRA transmission costs and defer the BLRA transmission requirement to a subsequent rate proceeding. But Mr. Collin fails to note that these transmission facilities have been or will be placed into service to meet the needs of SCE&G electric customers. They are a necessary part of the SCE&G system, and the utility is therefore entitled to recover those associated costs. We are proposing to continue to keep the transmission already in rates and defer the portion that is not currently in rates to the next rate case. Mr. Collin also argues that the Toshiba settlement proceeds, as well as the $575 million of refunds under the customer benefits plan, or $880 million under the alternative plan, be used to reduce the allowed N&D cost recoverable through the capital cost rider. Under the customer benefits plan, Dominion Energy's proposed $1.3 billion upfront rate credit, an amount much greater than the Toshiba settlement, will immediately be returned to customers. We believe the highest net present value to customers is achieved by returning the cash to customers upfront versus through any other mechanism. Under the alternative plan, Dominion Energy will refund a total of $1.91 billion, an amount equivalent to the approximately $1 billion Toshiba proceeds to be credited evenly over 20 years, as well as $880 million in previously collected amounts under the N&D over 10 years, which approximates the time value of money associated with refunding the amounts equivalent to the Toshiba settlement over the 20-year period. SCE&G could not provide either of those benefits to customers on its own. Mr. Collin also proposes that Dominion Energy recover N&D costs on a levelized basis. We believe that a declining revenue requirement, as opposed to a levelized one, is more appropriate because it matches the regulatory accounting construct of an abandoned asset with a declining rate base. Any proposal that reduces the rate base by the amount of refunds does not work for the merger economics. To ensure rate stability for customers, Dominion Energy structured the refunds in the customer benefits plan and the alternate plan so that customers pay the equivalent of levelized N&D bills for approximately 8 years and 10 years, respectively, before N&D bills further decline as a natural result of amortization. Mr. Collin also recommends that an ROE of 9.1% be applied to allowable N&D cost. The 10.25% ROE requested under the customer benefits plan is consistent with the range provided by SCE&G witness Robert Hevert, and in fact falls at the low end of his range. The alternate customer benefits plan includes an ROE of 9.9%. I appreciate the opportunity to outline the alternative customer benefits plan and respond to criticisms and recommendations related to ORS's proposal. Thank you. This concludes my summary.
Mr. Chairman, Hearing Officer Butler, if I could address a housekeeping issue here with respect to Exhibit 52, which was mentioned in Mr. Pruitt's summary because we reserved admission of that exhibit. And if I may just put it up on the stand to remind folks about it, and looking in particular at page 2, Mr. Pruitt, was this exhibit prepared by you or under your supervision?
Yes.
And on page 2 of the exhibit, there were some questions.
Make sure you stay in front of that microphone so they can hear you.
Thank you, Mr. Chairman.
Yes, sir.
Mr. Pruitt, there were some questions about the figures on page 2 of this exhibit. Did you prepare those figures for the Commission's consideration in this case?
Yes, I did.
And do these figures going across 147.53, 140.40, 136.07, and so forth represent the typical residential customer bill to your understanding under these various alternatives?
That's my understanding.
And do the blocks above represent the N&D component of those bills?
That's my understanding as well.
And do you believe that these figures reliably represent the total bills and the N&D component of those bills?
Yes, in my opinion, they do.
Right. Your Honor, at this time, Mr. Chairman, at this time, I would ask that Exhibit 52 be admitted to the record.
Okay. Exhibit 52 will be entered into the record.
Thank you, Mr. Chairman. Now turning to the final witness in this panel, Dominion calls James I. Warren to the stand. Sir, if you would state your name for the record.
My name is James I. Warren.
And Mr. Warren, by whom are you employed and in what capacity?
I'm a tax partner in the Washington law firm of Miller and Chevalier Chartered.
Mr. Warren, have you prepared or caused to be prepared under your supervision rebuttal testimony of 23 pages that was previously filed with the Commission in this docket?
Yes, I have.
Do you have any changes or additions to that pre-filed testimony?
I do not.
If I were to ask you the questions appearing in that pre-filed testimony here today, would you provide the same answers?
Yes, I would.
Mr. Chairman, I would ask that at this time the pre-filed rebuttal testimony of James I. Warren be read into the record as if given orally from the stand.
Mr. Warren's pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Warren, have you prepared a summary of your testimony?
Yes, I have.
We'll pass that out at this time. Mr. Warren, would you please deliver your summary?
Surely. Good morning, Mr. Chairman, Commissioners. I appeared here today on behalf of Dominion Energy, Inc. in support of the joint petition filed by Dominion Energy and South Carolina Electric and Gas Company. My testimony responds to three aspects of the direct testimony of Lane Collin, filed on behalf of the Office of Regulatory Staff. The first and the most significant is the impact of SCE&G's net operating loss carry forward, which I will refer to by the acronym NOLC. At the outset, let me say that while the testimonial discussion of this issue may seem a little bit like particle physics, it's actually not that complicated. The issue is simply about how to reasonably divide up a particular tax attribute, in this case an NOLC, between customers and shareholders under a disintegrated approach to the merger proposals. I also address one of the impacts of the reduction in the corporate income tax rate under the Tax Cuts and Jobs Act, which I'll refer to as the TCJA. Specifically, the timing of the flow through to customers of certain excess deferred taxes, and again, excuse me for one more acronym, I'll refer to that as EDIT, excess deferred income taxes. Lastly, I address the amortization of SCE&G's NOLC-related deferred tax asset. I'm also here to respond to the best of my ability to any other tax-related questions that the commissioners might have. With regard to the first issue, it's necessary to understand the tax attribute here, the NOLC. Taxpayers are taxed on taxable gross income net of deductions, same as individuals, same as your own tax returns. A net operating loss, or an NOL, is created when in any year a taxpayer reports more deductions than it has taxable gross income. So if a corporation has $100 of gross income and $200 of deductions, it creates a $100 NOL. Corporation can't pay less than zero tax in any year. So unless the NOL can be carried back, which it could be to a limited extent prior to 2018, that means that $100 of its deductions do not reduce its current tax liability. You can't get better than zero. In recognition of this, the tax law permits an NOL to be carried forward. That's the NOLC. In the year to which it's carried, an NOLC is treated like an additional deduction, reducing the amount of taxable income in that year. Now, in 2017, SCE&G generated a large NOLC due to the large NND-related deductions it claimed in that year. That's the tax attribute at issue here. The NOLC is a future tax benefit that will be realized when in a subsequent tax year it's used to reduce taxable income. It therefore represents deductions claimed for which there has been no current benefit, though there will be a future benefit to it. It's the accounting recordation of the NOLC that tends to create the confusion here. All deductions are recorded as if they produce current tax benefits. These are reflected as standard deferred tax liabilities, just like what you expect to see when a company claims accelerated depreciation. But those deductions that create an NOLC don't produce any current cash tax benefits. So an offsetting entry is recorded, a deferred tax debit, to reflect the fact that to the extent of the NOLC, the deductions do not reduce any taxes. Now, in rate making, deferred taxes, specifically net deferred tax liabilities, reduce rate base. This is because they represent an interest-free source of capital that reduces the cost of financing in the utility's rate-based investment. Thus, customers benefit from the presence of this cost-free capital. To determine the correct amount of the cost-free capital, it's necessary to consider not only the deductions claimed, that is, the deferred tax liabilities, or DTLs, which reduce rate base, but you have to consider the extent to which those deductions didn't defer any tax. The NOLC-related deferred tax asset, or DTA, which increases rate base. You have to consider both of those. In our case, there is no disagreement between the parties as to any of the principles described here above. The disagreement is over how much of SCE&G's NOLC should be reflected in regulated rate base. In the Customer Benefits Plan and the Alternative Customer Benefits Plan, the joint petitioners included the entire NOLC-related deferred tax asset DTA in rate base. It was included to achieve a specific overall economic outcome. As a result, the treatment of the NOLC as proposed should not be analyzed independently. If the outcome of the plan is acceptable, then the NOLC should be acceptable as a component of it. But Mr. Collin does exactly what I stated shouldn't be done. He takes the NOLC and at least purportedly applies what I'll refer to as the benefits and burdens principle to it. That is, both customers and shareholders get assigned that portion of the NOLC produced by the costs that each group bears. His proposal is to assign $67.1 million of the total DTA, or about $175 million of the NOLC, to customers and all the rest to shareholders. In my testimony, I apply the very principle he uses and demonstrate that his number is completely unreasonable, even using his own approach. My testimony further points out that notwithstanding that for regulatory purposes, we are all presuming that the NOLC is attributable to NND deductions, The IRS has a different view for purposes of the tax normalization rules. For purposes of those rules, the last deductions taken are not NND deductions, but accelerated depreciation deductions. Moreover, where an NOLC is attributable to accelerated depreciation, the IRS has concluded that it must be reflected in rate base. The amount of SCE&G's NOLC that Mr. Collin proposes to recognize in rate base is significantly less than the amount it would be required to recognize if the NOLC was related to SCE&G's 2017 accelerated depreciation instead of its NND deductions. That is, under the IRS view of the world, the amount that he proposes would be deficient. My proposal, the proposal offered in my testimony, would satisfy the IRS in that regard. The second issue relates to excess deferred income taxes. In years between 1988 and 2017, when SCE&G claimed and was able to use certain tax deductions in excess of its corresponding book deductions, most particularly accelerated depreciation, including bonus depreciation, it deferred its income tax liability by an amount equal to the excess of the tax deduction over the corresponding book expense multiplied by the corporate tax rate, which was 34 or 35%, depending on the year. The cash benefit of the income tax deferral was retained by SCE&G, recorded as deferred taxes, and reflected in rate base as an offset to rate base. It was anticipated that the amount of the deferral would eventually have to be paid back to the government in the form of higher income taxes, when later on in the life of the depreciable assets, book depreciation would exceed the available tax depreciation deductions. However, the reduction in the income tax rate enacted as part of the TCJA altered the amount of the anticipated repayment liability. When eventually the higher taxable income is produced, it will be taxed at 21%, not 34% or 35%. Consequently, a portion of the deferred tax reserve previously recorded on the presumption that it would be taxed at 34 or 35% is rendered unnecessary for that purpose. This portion is excess or EDIT. The TCJA establishes a rule that's very similar to the one established in the Tax Reform Act of 1986, when the corporate income tax rate was reduced from 46% to 34%. Specifically, it defines the term excess tax reserve as the excess of the deferred tax reserve required by the normalization rules. That is, the deferred tax reserve that is attributable to accelerated depreciation as of the day prior to the TCJA tax reduction over the amount that would have been in that reserve had the new lower corporate tax rate been in effect for all prior periods. The excess tax reserve can be flowed through to customers no faster than as the underlying timing differences reverse using something called the average rate assumption method, or if the utility doesn't have the records necessary to apply the average rate assumption method ratably over the remaining life of the property. There is, however, no restriction in the tax law on the timing of flowing back to customers any of the remaining EDIT balance. The flow through of those amounts, which I will refer to here as unprotected EDIT, can occur at whatever rate the regulator deems reasonable and appropriate. Mr. Collin proposes that all unprotected EDIT be flowed to customers over 5 years. I disagree with this. It's my recommendation that the Commission exercise its discretion to allocate a portion of this EDIT to all customers who pay for and support the assets that created the EDIT, rather than to those who just happen to be customers for the next 5 years. This is the same treatment that is required by the tax law for protected EDIT. It's for this reason that the customer benefit plan's approach to apply the average rate assumption method, the tax law mandated procedure, to all plant-related EDIT, both protected and unprotected. It is a more equitable and reasonable approach than that proposed by Mr. Collin. It's also the case that EDIT represents cost-free capital so that customers continue to benefit from any unamortized balance as a reduction in rate base. A rapid amortization would therefore increase rate base for later customers. Accordingly, under the ORS position sponsored by Mr. Collin, while the initial revenue requirement will be lower because of the shorter EDIT amortization period, that revenue requirement to be recovered through customer rates will increase after 5 years. It's not sustainable. Under my proposal, longer amortization of the EDIT to match the life of the corresponding assets, the revenue requirement will remain more stable and there will not be this market increase after 5 years. Again, I believe this is a more equitable treatment and matching of the benefit for both current and future customers. The last issue, the period for amortizing the NOLC-related DTA appears not really to be the subject of disagreement. Mr. Collin proposed that the DTA should be amortized over 10 years. I disagree with that. You can propose to reverse the DTA over 5 or 15 or 50 years. However, in fact, it will only reverse as the NOLC is used. No faster and no more slowly. I believe Mr. Collins' rebuttal clarifies that his 10-year period was merely an estimate of when the NOLC would be used, not a designated accounting treatment. If that is so, then we no longer disagree with respect to the third issue. This concludes my summary. I look forward to helping the Commission address any tax questions that they might have.
Thank you, Mr. Warren. And Mr. Chairman, I'm happy to report there will be no quiz on this later. At this time, these three witnesses are available for cross-examination from the parties or questions from the Commission.
Okay, before we get to that, I think we have some question on Mr. Purett's exhibit associated with his supplemental rebuttal. It was filed as confidential and is under seal. Is it in the book? It is in the book. Okay. So, do you want that entered?
Yes, Mr. Chairman, we do.
Okay. It will be entered as 126 and maintained as confidential.
Thank you, Mr. Chairman.
And,
Okay.
Mr. Chairman, Bob Guile, Friends of the Air Sierra Club, we move that any confidential exhibit, including that one, either be excluded from the record, so we object, or that it be made public at this time.
I think we've addressed this issue before, Mr. Chairman. This particular exhibit contains trade secret information, which, if it were released, could ultimately be harmful to customers, and we ask that its confidential designation be maintained. Parties that have signed a confidential agreement have access to it, and beyond that, we'll stand on our prior arguments.
Okay, we're going to overrule that, Mr. Guile, and we'll admit that as it is.
Thank you, Mr.
Okay, so now we're on for cross. Mr. Guile.
And, Mr. Chairman, I just want to say that I think I now support a flat tax system based on the witness's last testimony, and I intend to defer my cross-examination until sometime next century, I believe. No questions.
Thank you, Mr. Guile. ORS, well, go ahead, Mr. Cleveland. Or
Thank you, Mr. Chairman.
get close to that microphone, Ms. Edwards, please.
Thank you, Mr. Chairman. Because this is a panel, ORS I have cross-examination for Mr. Chapman. I believe Mr. Nelson has Mr. Pruitt, and Eric has questions for Mr. Warren.
Okay.
So my questions will be directed solely to Mr. Chapman.
Well, we'll do it that way.
morning, Mr. Chapman.
Good morning.
I'm going to focus my questions on the merger conditions. So just to kind of orient you to where I'm going to head first is in your rebuttal testimony on page 8, you are responding to ORS witness Mr. Baudino's testimony related to the merger conditions on credit quality. I'll give you a moment to turn there. All right. Very simply, wouldn't the ratepayer benefit if the Commission were to adopt the credit quality merger conditions that Mr. Baudino proposes?
Make sure you stay in front of that mic, Ms. Edwards, so they can hear you on the live stream.
I'm looking at the conditions regarding credit quality. Do you recall reviewing Mr. Baudino's testimony on this matter?
Yes, I do.
So the question I have is, wouldn't the ratepayer benefit if the Commission were to adopt the credit quality merger conditions that Mr. Baudino proposes?
My recollection of Mr. Baudino's testimony there and relating to these conditions is that in future rate proceedings before the Commission, the capital allowances, both in terms of return on equity and allowances for the cost of debt, would be limited in some way to factors not related to the facts and circumstances of South Carolina Electric and Gas at that time. And my rebuttal testimony was in response to that concept, that I believe that a fair capital return on both equity and debt in future rate proceedings should be reflective, as is my understanding of the norm in the industry, of the facts and circumstances surrounding the company in question at that time.
Our concern is that the customers should not be subject to adverse effects of the merger in the form of poor credit quality. Can you understand ORS's concern in that matter?
As relates to any concern regarding a negative impact of this merger on the credit quality of SCE&G, I can understand why that may be pointed out as a concern. It seems to be the exact opposite of what the impact is likely to be, but I do understand in that respect, as relates to specifically negative credit implications of the proposed merger.
So you would oppose the second sentence of the first bullet, that the commission shall not allow Dominion or SCE&G to pass through increases in the cost of equity due to adverse effects from the proposed acquisition or from any additional risk due to imprudent actions by SCANA or SCE&G. You are opposed to that sentence. Is that a fair statement?
Most specifically to the last phrase of that sentence, yes.
All right. Okay. Now, earlier you testified that Dominion does not support securitization to mitigate the impact on customers in this case. And you set forth several reasons for why Dominion does not support securitization, correct?
Correct.
Okay. Now, correct me if I'm wrong, but Dominion has supported legislation in Virginia on securitization.
I'm not aware of that, but very well could be true in other facts and circumstances in the past.
And if Dominion were so inclined, it could support securitization for the abandonment cost and possibly for storm-related expenses, and could actually assist in the efforts of the General Assembly to design and pass such legislation if it were so inclined.
If it were so inclined, yes.
Okay. Again, turning to the merger conditions, I could not find in the testimony, and you may not be the witness, so you may need to point me to somebody else, but I could not find one set of merger conditions that Dominion was proposing. For our witnesses, Mr. Lane Colin and Mr. Bodino are pretty much carrying the set of merger conditions. Can you point me to one set of merger conditions that are being proposed by Dominion under their proposals? Is there such a document?
I'm aware in my review of various witnesses' testimony and other public documents, a number of references to merger conditions. I'm not the witness to point you to a single document that contains the totality of those commitments.
Merger conditions.
Merger conditions.
Okay. Do you have an opinion as to whether Dominion would be willing to create such a document so that the Commission can easily compare the merger conditions offered by Dominion versus, say, other parties in this case?
Yes, ma'am. That sounds like a very good question for a lawyer, which I'm unfortunately not.
Okay. Thank you. Now, have you had a chance to look at Mr. Colin's list of merger commitments in his testimony?
I read his testimony. I did, yes.
Did he misstate any of the merger commitments that have been proposed by the applicants? Did he misstate any of the proposed? I'm trying to make sure that we're clear on the proposal. So did you identify any misstatements by Mr. Colin with regards to the proposed merger commitments set forth by the joint applicants?
That area is not really my area of expertise or the area which I was prepared to testify on. So I've read those documents, but I don't. I'm probably not best positioned to comment on the accuracy of them.
All right. Do you have an opinion as to the best witness to approach on those points?
Again, that would be a legal question, so I defer to legal counsel.
Okay. All right. With regard to, and you may again have to point me to a witness, or you may not be able to respond to this one. But with regard to goodwill, transaction costs, and transition costs, ORS submitted a proposed merger condition on that. Would you be the person that I could ask questions about that on?
Questions regarding a specific proposal that's been made by the ORS?
Yes, with regard to goodwill, transaction costs, and transition costs. Would you be the best person for me to talk to about that?
I guess that depends on the exact nature of your question. I'm happy to try. Okay. As relates to the legal documentation of such, probably not, but conceptually on the exact charges, I'm happy to give my best.
I would just mostly wanted to see if with regard to the language that was Dominion opposed to the language put forth by ORS.
In that relation to this topic, looking at what you have on the screen there regarding FERG financial reporting requirements, I'm guessing I'm not the best person to respond to that since I am not familiar with what that is. So as it relates to the specific mechanisms, I would defer to another witness.
Okay. ORS also had a condition with regard to local employment, specifically that Dominion will seek to minimize the reductions in local employment by relocating some of Dominion Services, Inc. shared and common services functions and activities to Casey from Richmond. Would you be the best person for me to talk to about that merger condition?
Could I say that as that topic relates to additional testimony from ORS witness Colin regarding potential for headcount reductions, that's something that we have quite a bit to say about, and I would defer in that entire area to the next panel of witnesses from Dominion.
Fair enough. Thank you so much. All right. I am making my way through, and then I'll shift gears away from these merger conditions. One last item, the organizational structure of SC&G as a result of the merger. ORS witness Colin included a paragraph that Dominion Energy shall not make changes to the organizational structure of SC&G after the merger without prior authorization from the Commission. Is that, again, something that I should approach with a different panel?
That would be best addressed by the following panel of the Dominion Energy witnesses.
Fair enough. Thank you so much, Mr. Chapman. Turning to a different set of questions, one of the things about this case is there's several proposals put forward, one that has an upfront refund, and of course the most recent alternative, which really, as was set forth, is to lower the rate going forward. You are familiar with both of those proposals?
Very familiar.
All right, thank you. With regard to if this commission were to adopt the proposal of lowering the rate going forward and not an upfront refund, what kind of education will Dominion do for the customers if this merger occurs and if the commission were to adopt that alternative proposal?
May I clarify by that, do you mean an adoption of the alternative customer benefit plan as put forward by the joint applicants?
Yes. Yes, sir.
At this time, we don't have a detailed public or customer education program regarding that plan. Obviously, quite a bit of information regarding that proposal is in the public domain, well covered by press outlets in South Carolina and nationally. But we would, as is our custom, certainly have a comprehensive customer educational program to highlight the merits of that case as relates to long-term rate relief.
Okay. And I'm just going to put it out there bluntly, Mr. Chapman. As part of that education, is it Dominion's intent to explain that the reason there is no refund is because of the commission adopting the alternative plan, or because ORS made certain proposals? Where I'm going with this line of questioning, Mr. Chapman, is as part of that education campaign, is it Dominion's intent to, kind of point the finger back to the regulatory bodies?
It's an excellent question. We, as background on my thinking there, as in our preparation of the original customer benefit plan, we very much believed and still believe that the best way to provide customer relief is to make it available immediately. I think we've probably addressed that enough in our testimony and publicly, et cetera. The alternative customer benefit plan, however, is also ours, and we own it, and we think it provides equal, although different, customer benefits over a different time period. And I think that would be reflected in the way we talk about it if it is an accepted plan by all the parties.
Okay. To the extent that Dominion does prepare a consumer education plan on this point, would you be willing to share that plan with the Commission and ORS before you enact it?
I would defer to the legality of that request to others, but conceptually, again, I think there's nothing that would be. I mean, we're talking about a plan that would be made public, so there's nothing to hide. Don't know how the legality of that would work, but that would be in the spirit in which we operate around such topics.
All right. All right, so turning to a different topic, and I am mindful, Mr. Chairman, that I'm going through this as quick as I can. Another issue that would like to discuss with you is, Mr. Chapman, let me back up a second. Mr. Chapman, are you familiar with ORS's mission? What our statutory mission is as the Office of Regulatory Staff?
Generally, yes.
Okay. All right. So if I were to tell you that we represent the public interest, which is defined as all customer classes and preserving reliable, high-quality services, you would not dispute that?
No reason to dispute that.
Okay. So you would understand that it's ORS's role to look both at the rates the customer's paying as well as the service quality?
Yes.
Okay. All right. And so it wouldn't be a surprise to you that ORS is pushing for the best deal for the ratepayer. That would not come as a surprise to you.
That's what we expect in every jurisdiction in which we operate.
Okay. Thank you. And as such, with regard, for example, to as part of this case, you've asked for $32 million that's currently in revised rates in carrying costs and transmission to continue to be charged as part of the proposal before the commission from the joint applicants. And I believe that's in your testimony.
To clarify, I believe we have requested continued inclusion in rates of used and in-use and useful equipment in the transmission area, yes.
Okay. And with regard, you're familiar with rate cases, right? Generally speaking, rate cases for electric utilities. I would imagine you are.
Yes, ma'am.
I would think you are. All right. So with the concept of used and useful, if, for example, some of these transmission assets were built for a 28-acre transmission switchyard that was going to serve 2 new nuclear units of approximately 1,100 megawatts each, it would not come as a surprise to you that ORS might see that as a transmission asset that is overbuilt?
That touches on a question that, in my mind, is more of an engineering and operational question of the definition of used and useful for certain assets. So I would guess that in a rate proceeding, it might defer to those kinds of experts, of which I'm unfortunately not.
There's this has been, I think, for Dominion as well, as Dominion was already operating in the state of South Carolina when it's made its proposal to acquire SCANA SCNG, correct?
Correct.
Okay. And in following this case, I think it would be fair to say that it has been a pretty contentious litigation, this case. Would you agree with that statement?
I agree with that statement.
Okay. And if this merger were to occur, what are the top 3 things that Dominion will do, I guess, in cooperation with SCNG, to rebuild the eroded trust that has occurred as a result of what ORS believes is a failure to disclose material information? How will you repair that damaged relationship? What would you propose?
Thank you. I don't have a list of 3 such items to respond to that question, but Dominion Energy, as you know, wasn't involved in some of the history that you're alluding to. Certainly aware of it from this proceeding and otherwise. We very much look forward to having a agreement between all the parties subject to approval of this commission, which would allow all the parties to sort of put this issue into the rearview mirror, if you will. And Dominion's focus here is to getting back to business and the things that we, again, focus on in all the jurisdictions where we do business, which is providing safe and economical energy infrastructure to our customers. So really, I mean, there are no three things, but really focusing on our knitting going forward, and having the issues, the historical issues that you mentioned, be just that history.
Thank you. I appreciate that answer, and this is my last question, Mr. Chapman. Along that vein of what you just stated, is it your commitment to this commission as Chief Financial Officer for Dominion to be open and transparent in your dealings, if with the commission and with ORS, if this merger were to occur?
Of course, the answer is yes, but I would go further to say that what you've just suggested is reflective of my experience as in the culture of Dominion Energy in every jurisdiction and with every regulatory body with which we interact.
Thank you, Mr. Chapman. That concludes my cross-examination.
Thank you. You're next.
Chairman and members of the Commission, William Hubbard on behalf of the South Carolina Public Service Authority, or Santee Cooper. Morning, Mr. Chapman. Morning. Chapman, do you have a copy of the joint application and petition with you today?
I'm sorry, not at this table.
I'll hand you one.
Thank you.
Mr. Chapman, is it fair to say that you agree with the content of the joint application and petition?
There's quite a bit there. I have read it in the past. I'm not aware of anything there that I disagree with.
I'd like to call your attention to page 7, which provides, and I quote, "This merger, including the associated customer benefits plan..."
Mr. Chairman, could I ask that he put that up on the TV screen?
Want to do the TV or use the Elmo, which is it?
Take it apart.
So you're going to use the Elmo?
Yes, I am. Yes.
It's good. Okay. I want to make sure.
To help me get it sized properly. Sorry, Mr. Chairman. I'm just going to put a number of pages up there. You can just put the whole page up if you don't mind. Okay. All right, sir. I'm on page 7.
Yes, sir.
And there it says, "This merger, including the associated customer benefits plan and other requisite terms, is demonstrably in the public interest, and the petitioners respectfully request that this commission issue an order to this effect." Do you agree with that statement?
I do.
All right, sir. I'd now like to turn your attention to page 23 of the joint petition. Paragraph 56. Which reads, "This merger, including the customer benefits plan, is in the public interest and will provide significant short-term and long-term benefits for SCE&G, its customers, and the state of South Carolina. You agree with that statement?
I do.
Next page is page 29. Paragraph 60. There, the joint applicants state, and I quote, "The merger is in the public interest and will provide benefits to SC, E&G customers and to South Carolina." Do you agree with that statement?
Yes, sir.
Now to page 40, please, sir. Paragraph 95. In the opening sentence of that paragraph, the joint petitioners state that, and I quote, "SCE&G joins with Dominion Energy in affirming that the merger is in the best interest of SCE&G's customers and the state of South Carolina." You agree with that statement?
I do.
Thank you. Now to page 51, please. In that request for relief, on page 51, you seek the Commission to approve the merger or, quote, "alternatively find that the merger is in the public interest or there is an absence of harm to South Carolina ratepayers as a result of the merger." You agree with that?
Yes, sir.
Thank you. Mr. Chapman, I'd now like to turn your attention to a discussion of the customer benefit plan proposed by the joint petitioners. You're familiar with that plan, correct?
I am.
Is it a fair characterization of that plan, among other things, that it, among other things, seeks to establish the recovery of certain costs associated with the project while attempting to ease the burden of customers affected by the project?
Yes, sir.
That is in furtherance of the goal laid out on page 3 of the joint petition, and I'll quote that to you. The SC&G recognizes the importance of attempting to ease the burden on customers of these costs to the highest reasonable extent, while at the same time ensuring financial viability of this utility and its continued ability to operate. Just for the record. Mr. Chapman, do you have any reason to dispute that Santee Cooper directly or indirectly serves approximately 2 million people in South Carolina?
No reason to dispute that. That's my understanding.
Would you agree that this abandonment has affected Santee Cooper direct and indirect customers as well as SCE&G customers?
I would imagine that is the case.
All right, sir. And you have no reason, do you, to dispute that military families are direct or indirect customers of Santee Cooper?
I imagine there are quite a few.
And that Walmart stores are direct or indirect customers of Santee Cooper?
I imagine, again, that to be true.
And members of AARP?
Yes, sir.
And small businesses as well as large energy users?
Confident that's the case.
Thank you, sir. I now refer you to page 5, line 15 of your direct pre-filed testimony. There, I believe you say that, or state that Dominion has a market capitalization of over $46 billion. Is that number still accurate?
Generally in that range. Of course, it changes day to day, but yes.
And now I'll refer you to your rebuttal pre-filed testimony, page 3. do you see language there that says that the plan allows for increased charitable giving and investment in the communities which SCANA serves, and most notably in South Carolina?
I recall that. I'm not seeing it here, but yes, I recall that being included.
All right, sir. And that statement recognizes, does it not, that Dominion has the ability to and should provide a benefit beyond simply SCE&G ratepayers?
Could you repeat the question?
Yes, sir. That statement, implicit in that statement and really explicit in that statement, is a recognition, is it not, that Dominion has the ability to and recognizes that it should provide a benefit beyond simply SCE&G ratepayers.
Yes, sir.
Mr. Chairman, I would just object to the extent that calls for a legal conclusion. I think we've discussed that issue, but he can answer to the extent he's not talking about a legal duty to any other customers.
Okay, sustained. We need to get out of that legal.
Do you have any reason, Mr. Chapman, to dispute that Santee Cooper was created for public purposes?
Not familiar with the exact history of its creation, but that is certainly logical.
And that it exists to serve public purposes?
That sounds, again, logical.
And do you have any reason to dispute that Santee Cooper is owned by and for the people of South Carolina?
That is my understanding.
I'd like to refer to your rebuttal testimony, page 2, lines 1 through 9. Does it not say there, Mr. Chapman, that you believe the plan was, quote, carefully and thoughtfully developed to provide a fair and equitable solution for all the stakeholder groups involved in this very unfortunate situation surrounding the now abandoned VC Summer Units 2 and 3 project?
That is what it says.
But that plan does not provide these benefits to the customers of Santee Cooper, does it?
It provides a number of benefits to the citizens of South Carolina, including those that are customers of SCE&G, those that are affiliated with organizations that would be supported by the charitable donations that you mentioned, and to employees and economic dependents on the activities of SCE&G that may or may not be customers of Santee Cooper. I don't have that knowledge.
All right, sir. But the plan does not explicitly provide benefits to the owners of Santee Cooper, namely the people of South Carolina, does it?
Explicitly, it does not.
Mr. Chairman, I have no further questions.
Thank you. All right, I've just been, yes, sir, Mr. Reed.
Well, you may be heading in the same direction I am. I know Mr. Hubbard jumped up there. I was assuming that ORS was going to finish its cross-examination.
I've been admonished about that from Ms. Wheat and Mr. Butler, so I need for ORS to continue with yours.
You want us to go to the next witness then?
Absolutely. Want to get all your ORS questions in one, since we are a panel here. That was my fault.
I thought you were doing just fine, Mr. Chairman. I was following right along with that. Mr.
No,
Pruitt,
I never have been worried about messing up in public, so.
Mr. Pruitt, I'm going to ask you just a few questions, honestly. There's not a whole lot, a couple topics here. Before we get started, though, if you could clarify a few things for me. First of all, would you agree with me, sir, that I pronounce your last name better than Chairman? Secondly, in reading your testimony and your CV, that kind of was the front of that, you have 2 degrees in, aerospace engineering, is that right?
That's right.
Does that make you a rocket scientist, sir?
Theoretically, but not really.
Okay. All right. Thank you. Just wanted to get that straight before we started questioning so I don't look too stupid here. Can you explain for me the difference between the SC&G and the Dominion tax sharing agreements or plans? Is that in your wheelhouse?
When you say tax sharing agreement, are you talking about the Tax Cuts and Jobs Act?
No, I'm talking about there is an agreement that exists between Dominion and its partner companies
that provides how the tax liabilities, or plus or minus when it comes to your taxes, there is a sharing agreement between Dominion and its subsidiaries or sister companies. Is that true?
To my knowledge, yes, but to your previous question, I'm probably not the best person to answer that.
Are you aware, did you review the information requests that were provided to ORS, in which there's a fellow by the name of William Kurz, K-U-R-Z. Are you familiar with him?
Yes, I am.
Okay. He's an employee of Dominion?
That's right.
Do you remember, or have you seen where his response to ORS's inquiry was that SC&G and SCANA would become parties to the existing Dominion tax sharing agreement post-merger?
Yep, I'm aware of that response.
So you would agree that that is still the case right now, that the Dominion tax sharing agreement is controlling. Is that correct?
That'd be my opinion.
And are you aware that there is no alternative allocation that's provided in the Dominion tax sharing plan?
I'm not aware of any.
Okay. And I want to try and ask you something here that's just kind of general, because I'm not real familiar with a couple of the terms that you've used. You use the term NOL DTA, which is net operating loss deferred tax asset. Is that the same thing as net operating loss accumulated deferred income tax? Is that apples and oranges, or is that apples and apples?
Can you say the second one again?
Sure. Accumulated deferred income tax, which is a term that we frequently use here with this commission. I was wondering if that is the same thing as the DTA that y'all are using in your testimony.
I believe so.
All right. And I'm not, we can get to Mr. Warren on that later maybe too, but I just wanted to clarify, because there seems to be, I don't know if it's a disconnect, but there seems to be a difference in the use of the terms, at least. And I just wanted to clarify that for the commission. Isn't it true that there is a substantial difference in the dollar amount between the ORS and the Dominion proposals regarding the treatment of NOL DTA?
Yes, right.
Do you know about how much that difference is between the two plans?
Yeah, it's quite substantial. I think witness Jim Warren can talk about it more.
So we're talking that this is really, even though it's somewhat confusing, that this is an important issue dollar-wise and the difference between the two cases, right?
That's right.
Okay, thank you. And is it true that, or isn't it true that the difference between the Dominion plan and the ORS's proposal primarily is whether or not the NOL DTA is tied to either abandonment or depreciation?
That's right.
Okay, and the Dominion plan is tied to depreciation, correct?
I would defer that question to Mr. Jim Warren.
Okay. So you're not familiar with whether or not the ORS plan is tied to the date of abandonment? Kind of a reverse of the question I just asked you, I guess.
Yeah, I mean, I would defer that question to Mr. Jim Warren here.
Okay. Real quickly, I wanted to ask you a question or two, too, about the transmission assets. In your testimony, on your rebuttal testimony, page 7, I think it was line 19, you've stated that those transmission assets, quote, have been or will be placed in service. So do you agree with that statement still?
Yes, I do.
And again, this was a question I think that was already put out there by previously, but isn't what we're talking about here is those transmission assets, you're saying all of those are either used now or they're going to be used in the near future. Is that correct?
That's my understanding.
Wouldn't you agree that those transmission assets and the switchyard that's out there were built to service 3 nuclear units?
Again, I think that question is probably better answered by an engineering witness. My understanding is that those assets are used and useful in the long term for the system in general.
No gold plating or anything there, then? That those are just actually what's needed by the company?
That's my understanding.
Thank you. No further questions. Thank you, sir.
Thank you.
Good morning, commissioners. Mr. James Warren, I'm Eric Omstutz with the Weich Law Firm representing ORS in this case. My questions will be directed to you. Your testimony focuses on deferred income tax matters and particularly on certain issues concerning the deferred tax asset arising from the deduction in SCANA's 2017 income tax returns of all of SCE&G's remaining N&D costs for the VC Summer Units 2 and 3 project. Is that correct?
Yes, that is correct.
Let's see if I understand conceptually what a deferred tax asset is in the context of an abandonment deduction. Assuming the Commission allows an amount of N&D costs for the abandoned project to be recovered from ratepayers, and since that amount was deducted in 2017 by the utility on its income tax return as an abandonment deduction, there needs to be a deferred tax adjustment to rate base. Is that correct?
Yes. Whenever the tax treatment of an item of income or expense varies from the book treatment, there will be a deferred tax consequence.
The abandonment deduction pretty close to immediately benefits the utility if the utility has sufficient taxable income in the year of the deduction to take advantage of that deduction. Is that correct?
That is correct.
Here, the abandonment deduction was really large, so the utility did not have enough income to take advantage of the full amount of the deduction in the year of the deduction. Is that correct?
Yes, that's correct.
And the amount of the deduction that the utility that cannot be taken advantage of by the utility in the year of the abandonment becomes part of the utility's net operating loss for the year for income tax purposes, correct?
Yes, that's correct.
And net operating loss is often referred to as NOL. Is that correct?
Yes, it is.
Now, the potential tax benefit attributable to the abandonment deduction gives rise for rate-making purposes to a deferred tax liability in the amount of that potential income tax benefit. Is that right?
Not exactly. The claiming of the deduction, whether or not it produces a benefit, is reflected as a deferred tax liability. Okay, it is booked in that way indistinguishably from a situation where there would be enough taxable income to use it. So from just looking at the deferred tax liability side, you couldn't tell whether the deduction could be used currently or not. Okay, yes. Is that a yes or a no?
No, I don't disagree with that.
Oh, okay.
As far as I know.
Okay.
And the amount of the deferred tax liability reduces the amount of allowed N&D costs to be recovered from the ratepayers. Is that correct?
No. The amount of the deferred tax liability just offsets the carrying value.
Does it have an impact on rates that customers pay?
Yes, it reduces the carrying cost associated with with rate base. Just as any deferred tax, accelerated depreciation or anything else reduces the financing costs associated with rate base for which customers are charged, so it benefits customers in that way.
And the larger the deferred tax liability, the more the ratepayers are benefited. Is that right?
That's correct, yes.
And there would be no need to have an offset to this deferred tax liability if SCANA had had enough taxable income in 2017 to take advantage of the full amount of the abandonment deduction, right?
Yes, that's correct.
But as previously said, the utility did not have enough taxable income to take advantage, and this gave rise to an unutilized net operating loss in 2017 for income tax purposes, right?
Yes, that's correct.
Given that the abandonment deduction was taken in 2017, the income tax rules applicable in 2017 governed, and so a portion of this unutilized net operating loss was carried back to SCE&G's prior 2015 or 2016 tax year, which allowed SCE&G to receive federal and state income tax refunds. Is that right?
That is my understanding, yes.
Do you know whether it's both 2015 and 2016 or one or the other?
I can't recall which year it was. I'm sorry.
Okay. And under those applicable rules, the ones that apply to 2017, the remaining amount of the unutilized net operating loss became a net operating loss carryover that can be used to offset taxable income in future tax years for up to 20 years. Is that right?
Yes, that's right.
And whether and to what extent the net operating loss carryforward will be used will depend on whether the taxpayer has sufficient income in future years to take advantage of the net operating loss carryforward, right?
Exactly right, yes.
Therefore, receipt by SCNG of a cash benefit for the net operating loss carryforward will come in future years. Isn't that right?
Yes, that's correct.
Because of this contingency, for rate-making purposes, the amount of the deferred tax liability that's been recorded for the abandonment deduction needs to be reduced or offset by the potential tax benefit that's not yet been received. And the way that rate-making does this is to create a deferred tax asset equal to that potential tax benefit not yet received. Is that right?
Yes, that's right.
And a deferred tax asset, is that added to rate base to be recovered from ratepayers?
It's not recovered from ratepayers. Again, what we're doing here is measuring the extent to which the company has deferred tax, which has provided a source of capital to the company. To the extent that it has deductions that create a net operating loss carry forward, it hasn't received that cash.
Correct.
And the deferred tax asset that you've referred to is the recordation, the memorialization of that fact, so that when you look at the level of cost-free capital in the possession of the company, you get to the real number. Now, those deferred taxes are, other than the fact that they impact rate base and thereby impact rates, they really are a creature or creatures of the relationship between the company and the taxing authorities. So it's the taxing authorities that are going to make good that future benefit. Their customers are not charged for it. They're just the deferred tax asset is just awaiting maturation, which comes when the net operating loss is actually used, and that's got nothing to do with customers. Customers can't do anything about that.
But the deferred tax asset offsets the deferred tax liability, i.e., it reduces the deferred tax liability, right?
Right, in recognition of the fact that the deferred tax liability didn't produce any deferred tax. It didn't defer tax. So it's an offset.
And we previously established that the larger the deferred tax liability, the more the ratepayers have benefited, right?
Right, because there's been more tax deferred.
So the larger the deferred tax asset, that's detrimental to ratepayers. Is that correct?
That's detrimental to the company. The company didn't get the cash.
But it's detrimental.
And that gets reflected in the rate base calculation. Yes, in that regard, you're right.
Now, if in a future year the taxpayer is able to take advantage of the NOL carryover, the associated NOL carryover deferred tax asset will go away. Is that right?
That's correct, because the company will get the cash.
For instance, if SCNG or SCANA has taxable income in 2018, this year, then it will use some of the NOL carry forward and correspondingly reduce the NOL deferred tax asset at December 31, 2018. Is that right?
If there is taxable income against which to offset the carry forward, yes, that's what will happen.
And so, looking at it generally, as we said before, a deferred tax liability reduces the amounts that ratepayers pay. And a deferred tax asset, by virtue of that offset, increases the amounts that the ratepayers have to pay. Is that correct?
That's fair. That's a fair statement, yes.
And the amounts at issue here relating to the abandonment deduction net operating loss carryover deferred tax asset are pretty significant, aren't they?
They are. Yes.
It does not seem that Lane Collin, ORS's expert, and you disagree as to the deferred tax liability associated with the abandonment deduction. Is that right?
You mean the credits, the recordation of the deductions?
Correct.
Right. All the deductions are recorded. We both recognize that.
And your client, SCENG takes the position that if NND costs are disallowed and therefore not included in the rate base, then the deferred tax liability associated with those disallowed costs should not be subtracted from rate base. Isn't that right?
Now, in which are you referring to a specific plan? One of those, either the customer benefits plan or the alternative customer benefits plan?
In either of those plans.
Yeah, I think that's correct. Yes, that's a correct statement.
Put another way, hasn't SCNG, or maybe it's Dominion, followed the principle that if NND costs are disallowed, it should be as if those costs were never incurred, correct?
I think that's an accurate characterization.
And logically, what follows from this is that the portion of the abandonment income tax deduction associated with the disallowed costs should be deemed never taken, correct?
Could you repeat that question? I'm sorry.
And logically, what follows from this is that the portion of the abandonment income tax deduction associated with the disallowed costs should be deemed never taken.
Yes, that's correct.
This approach ensures that the NND costs that are allowed and the deferred tax liability are calculated in the same manner, correct?
Yes, that's not the way the customer benefits plan or the alternative customer benefits plan were constructed, but in general, yes.
Yeah, we'll get to that issue that you just raised, because I think where the two of you disagree appears to be with regard to the NOL carryover deferred tax asset related to the abandonment deduction. And those disagreements could have a pretty large impact on what ratepayers have to pay, correct?
I mean, assuming, again, we're assuming that one or the other of the plans are not adopted. The plans are complete structures, including a specific treatment for the NOLC. That is not what we're discussing now. We're talking about now a separate evaluation of how one could treat the NOLC, but not the way the company proposed to treat the NOLC. Is that clear?
When you're saying the company, you're meaning Dominion?
Well, Dominion and the joint petitioner.
Joint applicant.
Yes.
Now, this disagreement relates to the fact that a large portion of the NND costs incurred on this project will not be allowed by this commission for recovery purposes. And those disallowed NND costs will effectively be absorbed by the shareholders. Is that right?
Well, that was Mr. Collins' proposal or his supposition. And again, for purposes of my testimony, I adopted his approach and presumed that would be the case also for purposes of our my discussion of the matter.
As stated earlier, you and Mr. Colin agree that only the portion of the abandonment deduction that is attributable to the allowed NND cost should be reflected as a deferred tax liability for rate-making purposes. Is that right?
That's correct.
Since SCANA did not have sufficient taxable income in 2015, 16, and 17 to take full advantage of the abandonment deduction, however, the deferred tax liability attributable to allowed NND costs should be offset by an NOL carryover deferred tax asset that corresponds to that deferred tax liability, right?
That's the general approach, and it's the approach that he took, and it's the approach that I discussed in my testimony. Again, it's not the approach the company took in crafting the two plans.
But from a rate-making standpoint, the normal way is what Mr. Colin does in terms of of matching the deferred tax asset to the deferred tax liability.
I would say that it's not it's what he purported to do. I don't think it's what he did, but it's what he purported to do.
Right, but the principle of sizing the deferred tax asset to the deferred tax liability is normal rate-making process, isn't that right?
It's what I'm most familiar with.
Okay. Now, you've mentioned the customer benefit plan, and also known as Plan A. Dominion does not limit the net operating loss carry-forward deferred tax asset to the portion attributable to the allowed NND costs. Isn't that right?
That's correct.
And rather, Dominion claims a deferred tax asset in the full amount of the unutilized net operating loss carry-forward arising from the abandonment deduction, including both the portion absorbed to be paid by the rate holders and ratepayers, and the portion absorbed by the shareholders. Is that right?
Yes, that's correct.
So, in other words, on the one hand, Dominion proposes that the deferred tax liability to be subtracted from the rate base, which benefits ratepayers, needs to be reduced to reflect the disallowed NND costs. But on the other hand, proposes that the NOL deferred tax asset to be added, which is detrimental to ratepayers, not be reduced to reflect the disallowed NND costs. That seems to be an inconsistency. Is that right?
But again, I mean, the plans are engineered economic, are geared towards achieving a engineered economic outcome. This was part of it. It had maybe inconsistent, but the question is, do you like the plan? Do you like the result, the economic result of the plan? Because that's what that plan. Either of those plans produce the economic result that would facilitate the closing of the merger. I don't think that the conventional allocation of the net operating loss carry forward, which you discussed, was not part of that plan. So yes, you're right, but in terms of the plan, that just wasn't a part of it.
So as you're summarizing Dominion's position, they're saying, look just at that ultimate number. How we get there may be some irrationality and departures from conventional practice with respect to deferred tax assets, but don't worry about that. Just look at the bottom line number. Is that correct?
Well, I hate to characterize the entire plan in that way, since I was not part of the design team. But I would agree that the treatment of the deferred tax asset is somewhat unconventional in the plan.
Now, on this question of allocating between shareholders and ratepayers, it appears...
Before we get to that one, we need to take a short break, so we'll break for 10 minutes.